All right. Hi, this is Curt, and welcome to another edition of Fire Law Roundup for July 11th, 2022. Brad, go ahead and take it away as I deal with the nonsense
Absolutely.
here.
So today we're going to start in Indiana, and we're going to deal with a claim by an EMT of gender discrimination over discipline imposed upon her that was not in equal seriousness, severity to other males. So again, this is just what we have is just a complaint. We haven't seen yet the response back from the department, I think, although that should be here soon. And here's basically what happened. Not complicated facts. The female, just to sum this up, the female tested positive at a breathalyzer for alcohol while at work. She was randomly tested pursuant to a random drug testing policy, which, as we all know, are themselves challenged often, whether it was really random or not, but that's not the claim here. And she, just to make this really simple, she is given a number of requirements to complete. But most important to me, as I look at this, is that the chief says, who's a male, said this is going to be under a new way of doing things, basically. And this is the first time they're under his administration. They're going to pursue these methods of reacting to somebody who fails a breathalyzer. But apparently, or allegedly, he makes a comment that we're going to make an example of her. Now, just to comment, I don't see a problem with that statement because it, has nothing to do with her as a female. You could have said that about anybody. But in short, what happens is she's given a series of requirements to complete, including a significant number of breathalyzer tests, which the complaint seems to call as random breathalyzer tests. I don't think those two things go together. So I don't know whether it's random or not when you say we.
Not really random if you're the only one. It's random in terms of time. It's not random in terms of who's going to go.
Right. So. But allegedly, that's what says you can do a number of random breathalyzers. But here's the short part. She's given 144 hours of discipline when she comes back. Yet two other males also failed the test, and they were given 23 hours of unpaid leave, right? Treated allegedly much less severely. So look, if these allegations are true, then on its face, she makes out a claim of gender discrimination. On the other hand, as we know, right, the employer gets to come back with, no, these circumstances are different. And a lot of times, why I always tell people, don't read a complaint and freak out. There's always something more. Who knows? Maybe she had a history. Maybe there was other things with other discipline, et cetera, with the males that she didn't know. Maybe.
Let me throw this one out because I read through the complaint and it refers to her repeatedly as EMT. Doesn't say firefighter EMT, refers to her as EMT. And if she is in fact an unsworn like civilian EMT and not a firefighter, I know Indiana doesn't have collective bargaining, but in the event, or maybe no, I don't think they do. But in the event that let's say the males are the males are not at will, and she is an at-will employee, and she's really under, a separate analysis, that may be a defense. I'm not saying it would win because you still got to explain why are you giving these people this penalty, and for the same infraction, you're giving other people this penalty. Now, if there's collective bargaining, I think in a collective bargaining jurisdiction, you may see something like that, but certainly on the face of it, it's pretty problematic. I would also recommend folks read the complaint. It's got some interesting things in there about the way that they did the test, which I think is a good way to do it. They have a breathalyzer on site, and then if you fail that, you're not guilty. It's just that means you got to go now for a more exacting complaint test, and that's important because for fire departments to try to maintain the calibrations on these instruments, you don't want to do that. So that gives you probable cause. You took the fire department's breathalyzer. It showed that you were, not zero. Something's up. You go now for, you go to a place that actually does this on a regular basis, has calibrated machines and so on. That part of it makes a lot of sense.
And I got to tell you, I liked it because when I was fire chief of my department, which was, unionized, at least a career, one of the things I worked out with the union was to address the situation that drug testing takes 2 days to come back. And I would have to pay, right? I would have to pay these individuals and plus overtime. So I'm like, listen, we're sending way too many people for drug tests that aren't coming back quickly enough for just minimal reasons. They hit a mailbox, they cut their face, whatever. So what I worked out is we found these tests called ICUP, ICUPs. It's really funny, but they're very
and somebody beat you to that product.
Yeah, amazingly. Yeah, that was somebody else's idea, and it's probably a fifth grader who owns it. But it's ICUP, but they're cups and they're drug tests. And they're very accurate. And so what I worked out with my union, right, because this is a negotiated issue, is they would have two options. They could either go to the hospital directly and that was our drug testing agent, or they could take this drug test and by peeing in the cup. If it is positive, we throw it away. There's no record of it whatsoever. And we put down their choice was to go to the hospital, no record whatsoever. Or if it was negative, which almost always was, then they come right back and we record a negative test. So we remove the probability that, they're going to come back positive. Our union liked it. Our village liked it. It was a good way. So I liked seeing this because I thought it was very similar to something I had done. So,
another aspect of this one, we have sort of a adversarial relationship sometimes with HR. HR doctrine is that discipline is between the employer and employee. And in firehouse culture, that doesn't always work. And here you see an example of where she's saying that they got different discipline than me because they're all talking behind the scenes. And I know there is a union, whether it's a collective bargaining union or more fraternal, but they get together and they can compare notes. Maybe they're not comparing all the notes because maybe there's other punishment that is more representative of what she got that was actually given to the men and it just wasn't included in the complaint. She might not have chosen to include it. So again, we're sort of fighting this battle with HR, I think, sometimes.
Absolutely. And look, there are other differing circumstances or circumstances that would justify a different discipline. Maybe they have 40 years on the job and she's got 40 days, right? I mean, there's a lot, there's other, especially when you're not going to pursuant to a CBA that may have a step discipline process, which I don't like, I know others like, but there's always ways to treat people, legitimate reasons to treat people differently, but on its face, she looks like she has a valid complaint.
Sure.
So we'll see. Okay. I love this one. I got to tell you, I think this was
scary.
A great one, this manslaughter charge.
It's scary.
Yeah, although I will say there's one thing I was a little confused, which I will ask you to clarify. But the headline from your blog, which is that a Pennsylvania dispatcher is facing criminal manslaughter charges for not promptly dispatching EMS. And frankly, here's what happens. He gets a call, and there's a lot of different PSAPs, and I presume this is not a big county, or maybe it is, but I don't know much about Greene County, PA. But the dispatcher receives a call. Well, I'll go back up one. This individual receives a call from a family member saying, hey, mom's not doing well, going downhill, something's wrong. That family member then calls 911, says, I'm headed over to the house and mom's not doing well. And if you believe it, and look, this is presumably all recorded, so there shouldn't be a lot in dispute if there's all recordings, but apparently she speaks to 911 for about 4 to 5 minutes on the phone. And everybody on our, on the video blog here knows in the first couple of seconds, they're figuring out who to dispatch and are dispatching the appropriate agency, right, as they're talking. But 4 to 5 minutes about whether apparently the individual would agree to be transported, which I've never heard that questioning before, ever. Do you think she'll want to go to the hospital if we go see her?
You know, as I read it, I was thinking, you know, maybe if we got a real sharp dispatcher and they've got like a mass trauma going on already, and they're really trying to be cautious with the allocation of resources, maybe those types of questions might fit in. Considering, you know, here in Exeter, we're 20 minutes for a mutual aid company to come in. And or maybe longer. It depends on where the mutual aid company is coming from. So, you know, it may make sense under certain circumstances, but according to the lawsuit, everybody was in. There were no other runs. So
they were waiting,
that excuse,
ready to respond.
That excuse was gone.
Right. So apparently the dispatcher then says, listen, call back once you arrive and you confirm she wants to be transported. Again, if true, an insane, right? There's nowhere in EMD that it says, you know, do you think you want to go? I mean, to me, this is implied consent. But nonetheless,
there's another aspect to this, and she told him on the phone that they did not have cell reception at the house. She was on her cell phone talking to him, and she said, "We don't have cell reception. I need to do it now before I get to the house." I don't know if the house had landline, and if the house had landline, I guess they could have called from there.
Right. But can you imagine? I mean, under this way of, and I'll keep continuing the facts, but under this way of thinking, anybody who calls third party, you know, like calling from Florida, hey, my mom's not answering the phone. I mean, how many, you know, did that
check on the well-being? Yeah.
Yeah. I mean, Jesus. Anyway, so the patient, who's only 54, died of internal bleeding the following day. So this is serious. Now there's also a civil lawsuit, right? So on one side, he's facing criminal charges under state law. And if this is true, it doesn't look good, because I read the components of the statute as you post them, and he's in trouble. I mean, but there's also a civil lawsuit where they're seeking money, same basic facts, but apparently they start using quotes from the dispatcher, like he would be using the ambulance would be a waste of resources. And that is an it's in quotes. So if that's a quote, you know, there's a lot of problems here. So I think there are some defenses, however, and let's talk a little bit about, because everyone's saying, oh, the county's going to lose a lot of money. Maybe, maybe not, right? So I didn't really look at all the complaints to see everything they could have alleged: negligent supervision, negligent training, vicarious liability, which we could talk about. And then again, of course, it's a municipality. So what's their immunity? And I don't know what the immunities are in PA. Normally dispatchers may have an immunity, but I think immunity saying we're not sending anybody is a little more beyond discretionary. But
yeah, well, they went further and alleged due process violations. So I think what they realized was Pennsylvania has some strong statutory and sovereign immunity, and they're going to try to get around that by alleging a denial of due process, deprivation of life without due process, due to deliberate indifference.
Refusal to provide public
but it's
services.
the term is deliberate indifference. So you know that the dispatcher was deliberately indifferent. Now, I think the biggest defense they're going to have has to do with causation and linking the 10-minute delay or whatever it might have been, linking that delay to the death. Certainly there's some liability, civil liability. Certainly there may be reckless endangerment and other criminal charges also. But in terms of the homicide and in terms of wrongful death or deprivation of life, they're going to have to show that 10 minutes made a difference.
Yeah. And I'd be alleging, frankly, and I don't know their laws, but I'd be talking about negligent infliction upon me, the 911 caller, saying, no, we're not going to go to your mother. We're not going to help her. I think that's where I really hang a big hat, because it's a lot of flexibility. It is clearly outrageous conduct for a dispatcher to say, no, we're not going to send somebody. And like you said, there are no extraneous circumstances to justify not sending an ambulance. But can you imagine being a kid and saying, your mother, I'm sorry, we're not going to send anyone to help her, basically, until you get there and tell us if she wants to go? Come on.
Well, one of the big cases, I forget where it was, but it was a young child, and the dispatcher convinced himself or herself that the child was just acting on their own and that the mom really wasn't sick. And the dispatcher is saying, well, put your mom on the phone. And the kid is saying,
Right.
She's unconscious. Well, put the phone up to her ear. So he puts the phone, and they say, well, we're not sending anybody. And she died. The mom died. So another example. And dispatching is tough. There's no doubt. I think very, very psychologically stressing, and people get burnt out in doing it. And whether that was a factor here, who knows? But
well, and here's the interesting thing. You raise a great point. Let's just throw this out. The criminal defense of this person may very well come down to, listen, I was overworked. They put me on overtime. I'm making all this up. Yeah. But the employee facing criminal charges is put in the position of having to attack their employer that I was stressed out, or I had PTSD, or I'm pleading temporary.
They knew or should have known.
Yeah, I mean, or I'm a horrible dispatcher. They shouldn't let me do this. Anyway,
you were negligent for hiring me.
You should have known I was incompetent. I'm going to use that. In any event, it's going to be very exciting, and I think to see this. Look, dispatchers shouldn't be worried that this is like a broad brush. We're going after dispatchers. That's not what's happening here. This was obviously a very bad, predictable outcome from some very off the wall actions. These are one-offs, we hope. Okay, very quickly, let's head to FDNY. This is unfortunate, and it is unfortunate, but we had a firefighter who's was retired on 9/11, and like many, went back and volunteered to work on the pile. Got sick, died allegedly as a result of working on the pile from 9/11 related cancer, and unfortunately sues under workers' comp. And again, remember, was not an employee, but I'll discuss that. But sues under workers' comp. The workers' comp board decided, and the third department, which is one of the appellate divisions, one of the 4 appellate divisions in New York, our second highest court, which is where this will end. But the appellate division decided that, I'm sorry, even if the law applied, you didn't file the required form. And then you do the right thing of on your website of putting up, here's the form if you need to. I don't know why that happened. I know a ton of mostly now deceased, even recently as a few days ago. I know a ton of persons who died, but they were all given good counseling by their employers or other people. Maybe I'm thinking what happened to try to excuse this, that they didn't file the form on time, thus losing their right to benefits. Maybe it was because of this. The individual wasn't working, again, for the FDNY. It was a volunteer.
I think that's the key. Yeah.
Yeah. And the volunteer may not have had access to all the information, and a ton of it went out. All the information that went out to the 911 pile workers, from construction companies and all these million different companies. There were a ton of resources, maybe because this person didn't have the link that they forgot to file the form.
Our friend Dave Fischler is all over this, and I thought about having him come on just to help us better understand this, because he's been really spearheading a lot of this stuff. Dave's an attorney in New York. He's actually semi-retired now in Florida, but he still is handling a lot of this. But we have this federal fund that was set up, and it's supposed to work sort of in conjunction with workers' comp. But in a normal situation, you have somebody who's on duty, they're on FDNY, or they're on a neighboring department or a USAR team or whatever it may be. So they're clearly working, and there's no question that they're working. And, workers' comp law is going to apply. The fund then will backfill or pay workers' comp, or however it works, whether you get the check directly from the fund or however that works. So that's fine. The problem is someone like this gentleman who was retired, and he volunteered, which is fine. They allowed that to happen. That's fine. There's no workers' comp coverage. So it's a gap. And what the state legislature did was create a loophole. And they actually refer to it as a loophole in the decision. But they created this special scenario where you will qualify, even though you weren't employed, you will qualify, but you have to fill out this form prior to your passing away. Right. And he didn't do that. And I know there was some kind of nasty comments that some people posted in social media about this that kind of thinking that the powers that be don't care about firefighters, and I think it's a little. The legislature actually went over and above, I think, to create this exception. But here's why I really want to talk about this for a minute. If you are someone who volunteered, and I know in Rhode Island we had a number of people, and I don't endorse this, but they self-deployed. And I don't, every one of us wanted to go to New York on 9/11. Every firefighter I know wanted to go. You don't self-deploy. You shouldn't self-deploy. That's not helpful. But if you are one of the people self-deployed, or you went as some sort of a volunteer unit where you weren't covered under workers' comp, you have until September 11th of 2022 to file that World Trade Center, a WTC 12 form with the New York Workers' Comp Division. And if you don't do that, you're going to lose the protection that the legislature created. So please, I've got a copy of the form. You can download it. It's got the instructions. Don't let this go. Get it done.
I had somebody ask me about it, and what they've asked me a while ago is, but I don't yet have cancer. I said, I don't care. Preserve your rights.
This is documenting that you responded.
Right.
That's all it's saying. It's not saying that I got cancer and it's from that. What it's saying is I responded, and therefore, if I get cancer in the future, I'm protected.
Right.
That's all it is.
And look, the government has a good reason to do this, and we'll move on, but the government has a good reason to do this. 50 years later is too hard to document whether you were really there or not, and what you were doing there, and whether you were actually exposed. So 20 years is virtually unheard of anyway. I mean, we've seen other examples, maybe with Agent Orange and some other things, but 20 years is a pretty good gift. And look, there is nothing I'm going to do ever to praise this state legislature, especially with what's happening now in New York State.
Wait a minute. I thought you had family members in the legislature.
They're dead. And that was when the Republicans were in charge, but not making this a political show. In any event, I just, New York has gone above and beyond for this by extending the period of registration to 20 plus years. And again, even if you don't think you're sick, file the form. I think that's got to be the point we're making. And as you said, you only got a couple of months.
Yeah.
So, okay, unfortunate outcome, but you know what? There's a lot of good lawsuits that are lost based on you didn't file a form. Okay, let's go to Texas. And I got to be careful because I know some of the departments. So I'm, like always, just sticking to the facts. But here we have a Texas firefighter. And now I have to tell you, I want to know the truth of this before I even get in. I want to know, I can't wait to see how this turns out. Because if I'm the department and I'm getting ahead of myself, I'm defending this with a video. So here's what happened. So a Texas firefighter claims that the termination was retaliation for participating in sexual harassment investigations and for making claims, etc. So basically what happens is we have a firefighter in Texas who's demoted, ultimately fired after complaining about a now retired chief's alleged sexual harassment. And the firefighter claims that he witnessed sexually harassing behavior of the fire chief, again, who since resigned, which raises some question about legitimacy. When you hear this, we don't know why he resigned, right? We just, he has resigned. In any event, a female HR employee complained to that firefighter also about the fire chief's behavior. It was reported, but the new, I guess the deputy fire chief then discovers a handwritten note. I don't really know much about the note, but discovers a handwritten note on his desk, questions the male firefighter about the note. And then apparently the deputy chief was acting unprofessional and threatening. And then 2 days later, right, short in time with this allegedly unprofessional threatening conversation, 2 days later, the male firefighter is placed on administrative leave from his position as the training chief without a really good explanation. So here's what's really interesting. And let's finish. So shortly thereafter, he said, look, the male firefighter says, I'm going to the EEOC for help, which is where one avenue of making complaints about unequal enforcement. And then there were him and 2 other employees participated in the investigation into the fire chief's harassing behavior. But then in December 21, just recently, he was taken off administrative leave. And then almost immediately thereafter on Christmas Eve, a really crappy time to fire someone for any reason, but nonetheless demoted to a firefighter. And then, so that's what we have. But here's what's really interesting. So you've got the allegation that, hey, I witnessed or was reported to me some sexual harassment. I reported that harassment and I was subsequently retaliated against for reporting it, etc. That's very simple facts. The opposite side, though, is going to be more interesting if true. So on February 7th of 22, right after this has all happened, Horton is accused, the male firefighter who reported all this, he's accused of violating the department's harassment policy. It turns out here he's allegedly, I'm quoting, right? Nobody yell at me. So it allegedly he was involved in public urination on a Black Lives Matter flag while on a fire department business trip to Wisconsin. So the department claims to have a photo of the incident, and it was allegedly or coincidentally on that same day where the male firefighter observed the chief engaging in sexually harassing behavior of the female HR, the female. So I'll break this up in a little bit. On the one hand, we have, hey, I witnessed things were reported to me by a female, I reported it, and you're harassing me because you demoted me. On the opposite side is, and I'm going to tell you my impression, which is nothing more than that, but on the opposite side is, yeah, the reason we're firing you, not demoting you, the reason we're firing you is because you did this heinous act and there's a picture of it, et cetera, and you were acting in the scope of your duties because you were on a business trip with the fire department.
Right, but here's
those things could be true.
Right, but here's the thing that, like, I'm going to try to simplify it even more. Okay, A testifies against B that B was sexually harassing a female. Okay, so A testifies against B. B happens to have some very damaging photo evidence against A. And after B is terminated or resigns or whatever, B now says, why are you going after me? Take a look at what Mr. A just did. And here we have a video of him urinating on a Black Lives Matter flag. Okay. Is that retaliation? You see where, and I think that these things can get very messy.
And to be clear, people have to understand, the test, which you and I talk about all the time, did the action I took, was that a result of a legitimate reason or a non-legitimate reason?
And here's the thing. I think that trip took place in 2019, I believe.
Yeah.
Okay.
So why didn't it get brought up before?
Why did he wait till 2022 to report it? Because obviously he was mad about being forced to resign.
Right. And
it was retaliation, but it's still, and again, retaliation is one thing or another. It still provides a reasonable basis for some sort of discipline. It still may, because
whether that was the reasonable basis, right? I mean, this is the question. You may have had very legitimate reasons to discipline, but you didn't use them.
Right. Until.
Right. So that is not acceptable. Storing a bunch of stuff in your back pocket to excuse why you may have allegedly sexually harassed or retaliated against somebody for participating in sexual harassment, just because you can pull stuff out of the past does not mean that's the reason you're going to terminate. You're just using that to retaliate against them, right? Oh, we knew about this stuff and saved it up. Here we go. That is not how we teach people to do these things.
Exactly.
If true, we don't know. Okay, let's go. Let's stay in Texas. Let's go to Dallas. Now we've covered this one.
We've covered this one before, and it was just the latest iteration in the ongoing saga of the firefighter involved here, and I guess the plaintiff is Kyle Vess. So,
And so just the short of it, and really, we should be able to link back to our video blog. We've discussed all the underlying facts, but look,
I can add a link to the description. Yeah.
Yeah, and so we won't go through it all, but in short, they think this homeless guy, the fire department thinks this homeless guy is starting fires. They basically go up and kick the proverbial crud out of him, threaten him, and he sues. It gets kicked out for procedural reasons, but the judge says, and you can come back, and he does. And this time we're moving forward with the suit over deprivation of his civil rights. We're going forward. There was some, I call it fleecing of the complaint, where some stuff was thrown out, but some's going forward. And I think whether he has an attorney now or not, in any event, this is moving forward. And Dallas is going to have to defend itself pretty well against this. This is going to be a tough matter to defend.
Yeah, I'll make a prediction. It's going to go away with a settlement. Because it's just, you've got somebody who did something that's really indefensible, regardless of the justifications for doing something, and self-defense, is certainly something that we all have a right to do. Under the circumstances, there were several other options, and certainly the level of brutality is troubling.
But the more important point about this case is what you raise at the end of your blog. And I really want to highlight this to everybody. You say this isn't rare, that numerous courts have held that a policy of lack of discipline and protection could, that emboldens officers to feel I can do anything and get away with anything, and I'm not going to have any discipline. That policy is actionable, or the effect of lack of policy or tolerance of that culture of violence. So, and I look at this kind of a Monell claim we're talking about, but if
deliberate indifference. Here we go again.
Exactly. But it's so important to point out, if you have a culture where things are happening, I don't care what it is, harassment, insults, assaults of people, if your department has a culture of doing something it shouldn't, and you either have a policy you're not enforcing, or you don't enforce any policy, meaning your policy is one of acceptance of that poor behavior, poor actions, you could lose a lawsuit on it. And you're not going to, because I've defended one of these recently and prosecuted one of these recently, you're not going to like who comes out of the woodwork to say, everybody knew this department or this chief or this one. You ain't going to like it. So you've really got to make sure having policies on your shelf get you a quarter way there, but they will hang you if you don't enforce them, and they will be used against them. So policies which gather dust will be the dust that is ultimately used to put you in your grave. That is just my belief.
One of the experiences, and I've been doing the toxic employee class for almost 2 years now, and doing a little bit more research and studies into the whole psychology end of this. But very often, fire departments, it's not conscious, but they treat high performers differently than they treat low performers. Okay. Sure. And when you have somebody who's a great firefighter, very aggressive, knows everything cold, is just tremendous pump operator, tremendous medic, all this stuff, that we tend to look past certain faults that they may have. And that can get fire departments into trouble. And not just in this particular arena, but also in a discrimination arena, because then we get somebody who's really not viewed as being a major asset to the organization, does the same thing that somebody who's the all-star. And then we find ourselves, why did we treat this person one way and another person a different way? And so high performers, and I don't know if that's applicable here. I don't know if this guy was a great firefighter or not, but I just, when I see a case like this, my sense is that maybe this person was known as being a really good firefighter, but he also had some faults, and nobody reeled him in. And like you were saying, nobody enforced the rules and got him, whether it's reprimands or whatever necessary to stop it from getting to the point where he's really, drop kicking homeless people.
Right.
So.
Okay. And, I will add one more point on this, just because it's, in the fire service, women in the fire service are generally newer than men, right? I mean, women in the fire service is still a celebrated but new event. when your first woman comes in, your first woman gets promoted. But as you said, the ones who are there longer will be treated better, which by default is going to be men are going to be treated better than newer males and females. But that's the standard that the females could use to say, I am being treated differently. I think it is a reasonable, legally reasonable basis to say, yes, we treated somebody because he has a 30-year history of not doing what you did on your first 6 months on the job. Whether male or female, that has no matter, but it does matter because women are going to be treated differently, and right, just by virtue of being newer, perhaps. So we should ideally try to erase as much of any different treatment, disparate treatment as we can, where longevity doesn't matter, right? Where longevity isn't as an important factor. And here's my thing: if you've been a male for employee for 30 years and you're drop kicking homeless people, I don't think your longevity there really matters much. All right, you've obviously reached the end of your time, if it's true. Okay. Lastly, we it's really simple, but
this is I just really wanted this for educational purposes, because just like, how does this happen? How does an explosion in Massachusetts lead the Detroit Fire Department pension system to file suit in Delaware?
Yeah.
How does this happen?
And you answer it pretty quickly. So basically what we have happened, and I remember this, if this is what I was thinking of, because I had a call like this once and it reminded me of it, where houses are blowing up next to each other over pressurized gas lines. And the NiSource, I guess, is the company who's responsible for this. They pled guilty to criminal charges. They were forced to pay over $50 million in fines. That obviously hurt the stock.
Yeah, 53 and 56 is 109 million total.
Yeah.
Some to the Fed, some to the state. So yeah.
And that affected the stock price, of which the Detroit pension plan was an investor. They it's called, just to be complicated for everyone, shareholders derivative actions. Basically say you took action which negatively affected our stock, and et cetera. In any event, they lose.
I'm going to apologize to my business corporations professor, who I became pretty friendly with, but I ended up with a B. That was like my lowest grade in law school, and he was on me about it, but I like you just said, that's about all I know about shareholder derivative suits. So there's a whole lot more. The attorneys out there that know what a shareholder derivative suit is, we wish you were on here to explain what it is, but essentially it's a shareholder not happy with the way that the board is running the operation.
Right. And to answer your question, because the corporation was incorporated in Delaware, they had a number of places they could have sued. That was one of them. And I think Bernie Sanders, Delaware, whatever, I'm assuming that it may not be a corporate friendly place. So maybe they wanted to sue them there. They're friendly in way of, pay any taxes. But that may be the reason. You see that with patent suits a lot. Well, they'll file in Texas because Texas is a.
I think they have a level of expertise also that's developed over a century of litigation down there from handling those types of things. So yeah.
Could be. This is the most political show we've done. Well, that's all of it, Curt.
That's it. And again, if you like what you've seen here, please click like, please subscribe. We really need, we're closing in. We need about, I think it's 48 more to get to 500. And once we hit 500, we're going to figure out how to do a random selection. And one of the folks who's registered will get a free copy of my book, Legal Considerations, brand new, hot off the press, 2022.
Autographed, hopefully. Autographed, hopefully.
Oh yeah, we could do that. We could arrange that too. So, all right. Well, that's going to do it for another edition of Fire Law Roundup.